Administrative process. Hypothetical situation. A few months ago, ABC agency sent the John H. Doe Trust an administrative presentment with a charge energy of $5,000. It wants or needs $5,000. You are the source, the banker. If you don't give it to them, they will use your dishonor to support a claim to $5,000 worth of trust property. You accepted it for access value $5,000, returned it, gave them an authorization to use your credit, exchanged your exemption for the discharge of the charge. Your acceptance is the return of the energy. They received your authorization, which may have been a bill of exchange, bond for discharge, or other instrument you chose to use. Now ABC agency has hired an attorney to bring charges in the public court against John H. Doe. A summons and complaint were delivered into your hands today. What do? 1. Realize this first: you are in the courtroom on your case. John H. Doe may have removed ABC's case to a different court by filing an amendment complaint requesting judicial review of your administrative process. The purpose of this case is to get a public order that will overcome the claims being made in ABC agencies against John H. Doe. You have to introduce evidence into the judge's file to give him facts upon which he can base his decision. If you are asking for findings to facts, he must have some facts in the evidence file. You don't want the respondent to enter evidence and have his be the only evidence upon which the judge will base his decision. If you want conclusions of law, he must have some law in the evidence file. The only way facts and law get in evidence file, the one the judge keeps in his possession, the clerk's file, you have to introduce it in open court, county recorder, county assessor, notary public, or other public officer, to the bailiff or judge's clerk, who will then hand it to the judge. Have a copy for the attorney also. You do not do this if there is a public defender. You have to introduce some law that supports your request into the record to give him something which to make conclusions of law. Putting this into the complaint as an exhibit and filing it with the clerk and giving notice of it to the respondent does not get it to the judge's file. More on this part of the administrative process later in this section. You need evidence and facts and law. What do you want the judge to do? This is the time, before you even do your administrative process, to decide what you want and what evidence you will need to support what you want the judge in ABC's case or the judge in your removed case to review the administrative process and issue an order confirming the facts contained in the notary's certificate of dishonor, or certificate of breach, or certificate of non-response, whichever is appropriate for the situation. Even you do not quote statutes, the notary's certificate is recognized as prima facie evidence of the facts contained therein. Look at the commercial statutes for your state. The UCC source is 1-202, OCGA section the 11th of January 202. Since your administrative process will result in a certificate, this is the time to decide what you want from the one that sent the presentment to the straw man. Put the horse in front of the cart, or you may find that your certificate did not contain the exact wording you want to use in the certificate. It cannot be changed after the fact because the notary could be accused of making legal determinations or practicing law. Do not put your notaries in jeopardy. Step 2. 3. Prepare the certificate of non-response. This is the notary's certificate. It is not yours. The notary will issue it to you. You will then be the holder of the certificate. It is like a bond in that it is evidence of the debt owed to you by the respondent who dishonored you by not responding or not complying with a duty. This certificate is 3 because it will be issued after the respondent has had 2 opportunities to honor you by complying with your request or performing a duty that is required of his office. His communication is not a response to your notice of acceptance and request, or to a notary's notice of non-response, if it addresses some other issue. If his response is an argument or testimony, he is in dishonor. What do you want this certificate to say? If you used a bill of exchange. Name of notary. Name of presenter. Name of acceptor. Description of presentment. Name of accused. State commercial statute regarding notary's certificate 47 Argentine pesos 3505 and 471202 in Arizona certificate statement. Notice that presentment was accepted and returned with attachments with a request to the presenter at his company at its address by cert mail with return receipt and cert of service notice of non-response with a second request. To the presenter at his company at its address by cert mail with return receipt and cert of service. Presenter refused requests. Presenter did not send notice of dishonor. Presenter did not cure his dishonor. Presenter agreed. He dishonored the acceptor. The acceptor accepted the presentment. The acceptor returned the presentment. The acceptor exchanged his exemption for a discharge. The acceptor presented authorization to use his exemption for court charges. The acceptor sent processing instructions with the authorization. The acceptor sent a statement of account showing a zero balance. His refusal to send the confirmation or notice of dishonor did not negate settlement. He and his agency have no capacity to pursue collection. Further collection makes him and his agency liable for $5,000 to straw man. Straw man can secure its $5,000 claim. Date. Notary signature. Notary seal. Notary stamp. Notary address. Administrative process number. See Sample 1. 3. Prepare your notice of acceptance. This is your acceptance notice cover letter to your acceptance of the presentment. You sign it. The notary mails it and gives you a certificate of service with her stamp and see Sample 2. See Sample 3 Standard Certificate of Service. T. Do you want to say? Certified mail hash. Name of notary. Name of presenter. Principal. Agent notice. Date. Reference note. Type of notice. Facts. The acceptor has accepted the presentment. The acceptor is returning the presentment. The acceptor is exchanging his exemption for a discharge. The acceptor is presenting authorization to use his exemption for court charges. The acceptor is sending processing instructions with the authorization. The acceptor is sending a statement of account showing a zero balance. The presenter's refusal to send the confirmation or notice of dishonor will not negate settlement. The presenter and his agency will have no capacity to pursue collection. Further collection makes the presenter and his agency liable for $5,000 to straw man. Straw man can secure its $5,000 claim. Signature of acceptor. Administrative process number. 4. Prepare the notice of non-response for the notary. See Sample 4. This is the notary's notice. B is your third-party public witness. What do you want it say? Certified mail hash. Name of notary. Name of presenter. Principal. Agent notice. Date. Reference note. Facts. Notary sent notice and request. By certified mail, return receipt requested, and certificate of service presentment was dishonored. Notary is attaching copy of first presentment to this notice of non-response. Notary is making a second request for same thing. Performance or statement is expected in 10 days. Caveat. Failure to cure breach will be agreement of parties to statements in first notice. Notary's signature. Notary's seal. Notary's stamp. Administrative process number. This completes the administrative process. You now have the certificate establishing a. That you accepted and returned and exchanged your exemption for a discharge. B. That your acceptance was received and accepted by the respondent. Twice. C. That the respondent refused to respond or comply with your request. D. That there is an agreement of the parties. E. That the respondent has no commercial energy to pursue collection. F. That you have all the commercial energy regarding the subject account. G. That you are in honor. H. That the respondent is in dishonor. The court presentment. The state, or city, or county, or an agency has just honored you with a court presentment. It is a verified complaint or grand jury indictment or traffic ticket. Do you feel honored? No. Why not? Do you feel fear, anger, confidence you can defend your position? Let's analyze this situation. State is used in this writing generically as a general term representing any corporate government organization and its agencies. U is used in this writing to represent the reader, the living soul. Straw man is used in this writing to represent an individual U.S. citizen, but not a state as defined above. What is this presentment? What are its components? It has your name on it. It does not have your name on it. It has a straw man's name on it. The moving party has named a straw man as a violator of a statute and has asked you to take responsibility for the violation. The state, city, county or IRS cannot file a claim against you. It is charging this straw man with a violation. Stop. It is establishing a value through an index associated with statute violations. This is ingenious. If you honor the presenter with an acceptance and return, the index establish the amount of credit you will provide to the state. If you dishonor, the index establishes the amount of property the state will take to get the credits it needs. The presumption is that you are in partnership with that straw man. In some cases, the index establishes how many months the state will hold your body for breach of fiduciary duty, while it collects your credits. It suggests a time period for you to answer. Stop. Don't trust this one. It establishes a time period for the straw man to answer on the public side, usually 20 days. If you don't accept in 72 hours from the private side, you will be in dishonor. The presentment is designed to help you into a dishonor. You don't have to go that way, if you don't want to. It is the name of the party bringing the claim. Someone has to approach you and ask you for your help. That person is taking a big chance. By signing his name, he could end up owing the amount the state is asking to provide. This is usually an attorney. He signs his name to it and becomes the attorney of record for plaintiff. State, through an attorney or other officer, has given you a court presentment, a request for your help. Options. You have options. Defend it. Argue about it. Conditionally accept it, ignore it. Accept it. You already know the right choice. You only have one good choice, accept. If you defend, you are refusing to take responsibility for managing the affairs of your business, the United States. Whether you want to admit it or not, the US is your creation. It continues in business because you authorized it. If you argue, you are in a controversy with your own business managers. If you conditionally accept, you are requiring the United States to prove it has a claim, when it is in receivership and cannot have a valid claim against you without your permission. If you ignore the presentment, you are acting like an irresponsible creditor and will lose our status as creditor. Your only choice is to accept. That by itself is not enough though. If you accept it and return it, you have not carried out the promise you made when you accept it. It's like signing the requisition form but not instructing anyone who write a check. You have accepted the presentment's charges, but you have not given them what they need, your credit. It is like promising to pay the electric bill but never getting around to it. If you do this, they will turn off the electricity. When you accept the presentment for value, you have to follow through with some type of instrument. If do not authorize the state to use your credit to settle the account after you have accepted, you are in dishonor. If you do not authorize the attorney to use your credit to settle the court account after you have accepted, you are in dishonor. The state and attorney will use your dishonors to charge their agents with authority to take the straw man's property, sheriff, and or your body, bailiff. Either way, the state and the court will get the use of your credit. The United States and its states are in receivership, so they have no credit of their own. They need your credit, and they will get it. The corporate counties and the cities are in this dysfunctional situation. They all need your credit. When they ask for it, give it to them. Follow through with your promise of acceptance and give them the use of your credit to cover, bond the charges. Be the creditor you can be. Take responsibility. Court. Remedy. 4. Accept and return the court presentment. If there is an assessed value on the presentment use, accepted for assessed value and returned in exchange for closure and settlement of this accounting. Date, signature. Ein. If there is no assessed value on the presentment use, accepted for value and returned in exchange for closure and settlement of this accounting. Date, signature. Ein. 4. Attach an asset, an authorization for the state to use your credit. A bill of exchange is one of the instruments you can use to authorize the use of your credit. It is a writing bill that you are giving the claimant in exchange for the discharge of the claimed debt charges. It settles the immediate charge requisition. It needs a date, an account number, a value, the name of the person who is to receive the credits, the name of the public creditor, Secretary of the Treasury, the name of the public pass-through, your straw man, instructions and instruction number, your name, the private creditor, your exemption number, creditor ID number, your signature. This is the endorsement. Instructions are important. Non-cash items require instructions. If you do not understand them, don't send them with your instrument, or do anything else until you understand what you are doing. Using other people's paperwork can be very, very detrimental to your success. Keep the instructions in plain English. These instructions are a great topic for discussion with your study groups. This is where the Treasury Tax and Loan Department (TT&L) of the bank is incorporated into the process, and where the electronic fund. The presentment is like a check. It is sent to you with a request for some kind of payment. If you endorse it and return it, they know you have approved the use of your credit. They can then use your endorsement, since they did not send a check made out to the straw man, to settle the debt account with an offsetting credit. They just need your authorizing signature to get the credit to enter on the books. Remember, there is no money transfer instructions are found. Be careful about putting information in boxes. It doesn't appear if it is in a box. Clerical information can be in boxes, but keep the substantial information outside the boxes. It is absolutely imperative that you understand there is nothing that is going to be transferred from the U.S. Treasury to the holder's bank. There is no funds transfer. There is no money transfer. There is no credit transfer. The credits are in your instrument with your signature on it with a dollar followed by digits greater than 0. When it is endorsed by the recipient and delivered to its bank, the credits are already there. They just need to be added to the account intended to receive them, and the use of the exemption needs to be approved by the Secretary of the Treasury. Approval is done through the TT&L department at the bank where the instrument is delivered. The electronic transfer is not a transfer money, credit, or funds. It is a transfer of digital information from the Federal Reserve Bank, through the Federal window, to the Treasury, where it can be approved or refused by the one who currently holds the office of Secretary of the Treasury of the United States. That is Timothy Geithner at time. He is also the one who keeps track of the national debt, which is partially owed to the people of American states, who have funded the United States with their credit since 1933. He is the trustee on the Chapter 11 bankruptcy of the United States. All bookkeeping in the U.S. is done through him. When you use your exemption, the national debt is reduced in equal proportion. Timothy Geithner, Secretary of Treasury, has to keep track of the debits and credits on the national debt. You cannot leave him out of the equation. Letter of credit. When you authorize the use not your credit, you must arrange for that credit to be approved by a third party in public. Timothy Geithner when the presenter processes your instrument. If you don't do this, it is like writing a check on an open bank account that has no balance or balance insufficient to cover the check. The private side, when you use our exemption to bond your acceptance of a presentment, the public auditor must receive notice of your intent. That is Timothy Geithner. The U.S. is not bankrupt, it is just in receivership. It can't make valid claims without an existing debt state, so it can get your credit anyway. The choice is yours. When the presentment is delivered into your hands, you become the holder. The state has honored you with presentment because you are in a position to help the state. When you endorse it as a holder, you are assigning the property interest in some associated substance equals your credit related to the presentment to someone else. If the presentment is signed by Jim Black, it should be returned to Jim Black. If the signature on the presentment is only a logo, and there is no other signature, the presentment should be returned to the name and address on the logo or letterhead. In that case, no man has accepted the commercial liability for the presentment. That does not really matter. You are not doing a conditional acceptance. You are doing an all-out acceptance. You don't care about anyone else, liability, because you are agreeing to be fully responsible. United States and all its offices, agents, employees had no commercial capacity to really make claims without evidence of an existing debt. That does not mean the state will not make it look like it is making claims. It needs your credit, so it is going to go through the motions of making claims. Do not embarrass the agents and point out that it has no commercial energy. It is your job to use your commercial capacity to fulfill the requisition without making it too obvious to the public. You are coming in from the private side. Provide your credit for the public's use. Most of the public do not know the state has no commercial capacity to bring claims. Keep your superior knowledge to yourself. The public is not ready for full disclosure of this yet. Recap. Private administrative process. 1. The notary sent your notice of acceptance with your acceptance and return to. The notary sent a notice of non-response or notice of breach if there is a contract involved. 3. The notary issued a certificate of non-response or certificate of breach to you. The certificate establishes a. That you accepted and returned and exchanged your exemption for a discharge. b. That your acceptance was received and accepted by the respondent, twice. c. That the respondent refused to respond or comply with your request. d. That there is an agreement of the parties. e. That the respondent has no commercial energy to pursue collection. F. That you have all the commercial energy regarding the subject matter. G. That you are in honor. H. That the respondent is in dishonor. Court process, some of it is private and some of it is public. 1. Accept for value and return the court presentment to the signing attorney. 2. Attach a credit authorization with instructions for the attorney to use to settle the court accounting. 3. Send a letter of credit to the Treasury. 4. Get a certified copy of the judge's oath and accept it for value. 5. Get a certified copy of the judge's bond and accept it for value. 6. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge. 7. File a notice of acceptance on the public side. 8. Get a copy of the court order appointing the attorney and accept it for value. 9. Prepare a letter of instructions to be mailed to the appoint 4D defense attorney and to request bond. 10. Check the clerk's file for a bond. 11. Prepare your bond to bond the case. 12. Remove the case to another court if necessary for judicial review of your administrative process that you have done on the private side has not appeared on the public side yet. Remember rule number 1. If you not let the public know what you are doing on the private side, it will appear you are ignoring the presentment. That will result in a default judgment due to your dishonor of the state's presentment. Get a certified copy of the judge's oath of office and accept it for value. That is evidence of the man's contract with the people, you, on the private side. You want him to take judicial notice of his contract with you. Filing it with a copy of the oath with the clerk will not accomplish that end, but it will give them notice that you expect the terms of that contract to be followed. You will have to enter the certified copy of the oath into evidence file in open court to actually have it make any difference. Get a certified copy of the judge's bond and accept it for value. That is evidence of the limited liability the judge person has in public when dealing with citizens and residents that are either owned or controlled by the corporations. It does not limit the private liability that the man has when dealing with the people, you, on the private side. Since there is no money to pay you if you are damaged by the actions of the judge, you will have to be satisfied with possible payment to the straw man, John, but that is not the reason you are bringing the bond into this issue. The reason is to notify risk management if necessary that you have been damaged by one of its insured persons. This is not the bond for the man, but a bond for the judge. The man is doing business as judge for the public from time to time, but he can also come under the private rules of equity, which is broadly defined as what is right. It is right for this man to recognize you as a creditor, but only if you perform like a creditor and avoid going into dishonor. If you dishonor anyone, you will fit the profile of a debtor, straw man, and he can ignore the private side. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge, not for filing to the clerk. Mark the envelope, private. Have a notary mail it by certified mail or give you a certificate of service. The return address is the notary's address. The components of the letter are: you have accepted the presentment for value and returned it. You have exchanged your exemption for the discharge of the charge you want settlement and closure. You are requesting an appearance bond at no cost to you. You are not disputing the facts. The parties have reached an agreement, there is no controversy. You have accepted the judge's oath and bond for value. Include a photocopy of the notary's certificate of non-response from your administrative process to confirm there is no controversy. See sample number 5. File a notice of acceptance on the public side. This will let the public know that you are doing something on the private side to settle the account. If you do not give notice to the public, it will be assumed you are standing mute. That is a dishonor. It results in default judgment or summary judgment. What would this notice say? It is your intent to settle and close the accounting immediately. You have accepted and returned the presentment. You have exchanged your exemption for the discharge of the charges you are requesting an appearance bond at no cost to you. You do not dispute the facts. You will enter a plea for the defendant. You want to be advised of the details of the hearing to receive the bond and enter the plea. You are bringing the argument of the parties and the judge's oath and bond into the case. See sample number 6. Public defender. If there is a court involved, the judge may appoint a public defender for the defendant. You are not the defendant. The straw man named on the presentment was chosen to be the defendant. Remember rule number 1. The The public and the private can never be mixed. They can't do it, and you can't do it. They don't ever mix them, so be careful that you don't either. If the defendant has a public defender, this is good. When the prosecutor signs the complaint, verifying it, and his signature is notarized, he is taking on the liability that may follow in the event it is discovered the complaint is not valid. He is taking a chance, because at that point, he is the only attorney or record. He has filed a form of notice of appearance by filing the complaint or filing the grand jury indictment. He technically represents the defendant until someone takes his place. He is counting on someone appearing in the case to defend against his complaint. If that doesn't happen, he is the responsible party and liable for all the costs paid for in the complaint or associated with the statute violation. If that does happen, he is off the hook. Almost 100% of the time, that is what happens. He is pretty safe taking the chance. Usually, the straw man named on the complaint gets a good attorney to defend him. That means the defense attorney has taken on the liability, right? Not so fast. He does not take on the liability until he signs a notice of appearance and files it in the clerk's file for that case. Once he is the attorney of record for the defense, he is on the hook. Here is an example in the state of Georgia that has codified the liability that the prosecutor could possibly take on. Read it very carefully. OCGA, the 4th of November 17, 2010. The 4th of November 17. Imposition of costs and jail fees upon prosecutor or complainant. The prosecutor's name shall be endorsed on every indictment, and he shall be compelled to pay all costs and jail fees upon the acquittal or discharge of the person accused when 1. The grand jury, by its foreman, on returning no bill, expresses as its opinion that the prosecution was unfounded or malicious. 2. A jury on the trial of the prosecution finds it to be malicious, or 3. The prosecution is abandoned before trial. When it is thus abandoned, the officer who issued the warrant shall enter a judgment against the prosecutor for all the costs and enforce it by an execution in the name of the state or by an attachment for contempt. B. A magistrate may, in his discretion, assess costs and jail fees against the person who instigated the prosecution when, at a committal hearing, the action is dismissed for want of probable cause and the magistrate finds that the complaint was unfounded and malicious. This subsection shall not apply to law enforcement personnel. Now, he has to get someone to take his place. The likely taker on the position is the straw man named in the complaint, indictment, or traffic ticket. The straw man can't talk, so someone has to represent it. Usually, that is you, because you have a point to make, or a lesson to teach, or testimony that will prove your case. Wrong choice. This is almost always the losing proposition. Really good off-point paperwork has been put into court for decades with a very low success rate. The only way to win is to let the state win. I love win-win situations. How can you win and the state win at the same time? If you accept and return the presentment and exchange your exemption for the discharge of the charges, the state gets the credit from your exemption and you get the discharge when you bond the case. Well, that sounds easy, right? If the defense attorney can get you to act as the trustee for the straw man trust named on the complaint, the defense attorney is off the hook too. It is just a series of passing the buck, a hot potato game. The one who ends up with it has to pay the bill. The prosecuting attorney starts with it. It goes on to the defense attorney if he files a notice of appearance and then on to the straw man if you volunteer to defend, argue, testify, or join in the action in any way. It eventually ends up in your lap. You are stuck with the public liability, unless you accept and discharge it from the private side. Hot potato game. Prosecuting attorney. Defense attorney. Straw man. You. If there is no defense attorney, it just passes to the defending straw man. If you accept, it stays with the prosecuting attorney. He has the power to settle the accounting if you authorize him to do so. Get a copy of the court order appointing the attorney and accept it for value. This only if the judge appoints a public defender. Do not dishonor the court by refusing this privilege. The privilege is for the straw man, not for you. You can accept his services offered by the court and instruct him on how he will handle the case. You can do this because you are the creditor through your acceptance. You are in honor. Point the court, the prosecuting attorney, the clerk, and the appointed defense attorney are also in honor. Prepare a letter of instructions to be mailed to the appointed defense attorney. This letter to the attorney is your contract with him. If you do not establish the terms of your contract with him, the presumption will be that his is a defense attorney and is defending the defendant as an officer of the court. Get a certified copy of the letter to the lawyer from the notary before it is mailed to the lawyer. If time is crucial, fax it to the lawyer with a notation that it is also being mailed by certified mail RR. Have the notary mail it by certified mail RR and give you a certificate of service. What should this letter say? You are claiming an interest in the subject matter of this case intervening. Your property rights may not be protected by the existing parties. You are accepting the public defender appointment offer and returning it. You are requesting that the public defender put his bar card away. During this case you are requesting that the public defender act as your counsel instead of acting as an attorney. There is not controversy over the facts. He cannot start or join an argument. He is not authorized to defend the defendant. You are asking that he read this entire letter into the record in open court and file it with the clerk. You already have an agreement of the parties. Copy of certificate is attached. You are asking him to check the clerk's file for a bond and bond the charges. You are not disputing the facts. You want the prosecuting attorney to write the check to close the account. You will accept the prosecuting attorney's bond to bond the charges. You will start bankruptcy if necessary to locate your remedy. You want settlement and closure. You may require the defense attorney to file a notice of appearance in the case. See sample number 7. Check the clerk's file for a bond. There has to be a bond in every case in the event the complaint is a fraudulent claim. The presumption is that the prosecuting attorney's bar number is bonding the case, but there is no written evidence of a bond in the file. If there is no written bond, you can bond the case. The presumed attorney's bond is superseded by a written and signed bond. Get a certified copy of the docket sheet at the clerk of court, which will document that there is no bond in the case. A predated bond might just show up in the file later and minimize the effect of your bond. You can bond the case. The bond falls into the category of a replevin bond. It is not a replevin bond, because they were used in common law before the court systems, law and equity, were integrated. Now it has to be a bond that is in the nature of a replevin bond that is used as a replevin bond was used. 14. Prepare your bond to bond the case. This is the bond that completes the accounting for the court. It has the charge on the books, but it does not have the offsetting bookkeeping entry. The missing bond is what has the books out of balance. When you put your bond into the case file by filing it with the clerk of court, it balances the books. Attach a photocopy of the docket sheet to your bond to verify the lack of a bond in the case. I do not know why it is not notarized, but my guess is that it is coming from the private side and not the public side. If you have a notary public notarize your signature, you may be mixing private and public, and there are no prothonotari's to be found anymore. Even if we had protonotaries, that may cause a conflict, since we are totally under Admiralty law now. The bonds that have been used already were not notarized. If there is no defense attorney, you can enter your certificate of non-response into evidence and request judicial review of the administrative process. See sample number 8. 15. Remove the case. If the judge does not dismiss the charges by discharging the bond, you can remove the case into another court with an amendment complaint for judicial review, using the original case filing fee to cover the filings fees in the court to which it is being removed. This might mean removing the case from justice court to county court, or from county court to federal court, or from civil to criminal, or from criminal to civil. Sometimes the same judge can be on the original case and on the removed case. It is important to understand that you are not asking for a default judgment from the new court. You are asking for judicial review. You want a judgment in estoppel, not default judgment. The default judgment is already finished. The notary did that. The respondent was in dishonor. He defaulted on his duty to respond. When the notary issued the certificate of non-response, she was certifying the default. See sample number 9. Sit back and observe the play. You have done all your preparation work. Stay alert, but do not participate if there is an appointed public defender. Let him be your mouthpiece. Do not hire an attorney though if they do not appoint a public defender. You may have to participate enough to get your third-party witnesses as to the agreement of the parties and your status as the creditor on the record. Don't screw it up by dishonoring your own status as the creditor on the cases. They will try everything to get you to testify. Argue. Call witnesses, file an answer. Explain your private process. Dishonor the judge. Dishonor the prosecutor. Dishonor your lawyer. Join the commercial process. Hire an attorney. You can ask their witnesses questions about the certificates issued by the notary. Did you respond to my notice of acceptance and request for confirmation? Did you send me a copy of a notice of dishonor from a qualified third party? Did you cure your breach? If there is a problem with the judge or the other actors accepting your acceptance, there is always a wonderful question to ask. Your Honor, will your bond withstand the commercial liability of the charges this court is entering today? Do not participate in the courtroom drama.